emergency or constitutional emergency. So we'll talk a bit about what emergency powers usually include, and in particular, some of the debates in the field around emergency powers. We'll look at the role of the executive in relation to the legislature and the courts. In particular, ask questions around what are the limits on the executive in a time of emergency? Are there still limits, or is the executive effectively unlimited or unbound in a time of emergency? What kinds of concerns does that raise? We'll then turn to the region, Southeast Asia, and think about, well, what have we seen over the past year and a half in terms of legal responses to COVID-19? These range from constitutional responses, legislative responses, the use of executive power. And then we'll come to Myanmar in particular as one example of some of the real challenges that are faced in the region when using constitutional emergency powers and the way in which it's often contested. Okay, so key issues, as I said, first of all, this idea of, well, are emergency powers an exception to the Constitution? Does it allow a government or the executive to act beyond the powers contained in the Constitution, or is it actually within their limits? In particular, we're interested in what is the relationship between emergency powers and the rule of law and constitutionalism, and how, to what extent there might be limits on emergency powers. And then one aspect that scholars often look at, although perhaps is more absent in the region compared to other parts of the world, is what role courts play in a state of emergency. Now, to some extent, I think this is conditioned by whether courts play a prominent role prior to COVID-19 and what kinds of powers they have. But certainly it is possible for the courts in some contexts to still act as a limit on power and to act as a check and balance in a time of emergency. Okay, so to begin with, on what do we mean by emergency, or a constitutional emergency in particular? So here we're talking about the way in which a constitution sets out and defines the terms and conditions under which a constitutional state of emergency can be declared. Now, one thing we observe in looking at more traditional or older constitutions, whether it's the US Constitution, the Australian Constitution, even the Indian Constitution, there may be less detail around specific aspects of emergency powers. And we know even in the Indonesian Constitution that details are relatively sparse on how an emergency can be declared, or often a constitution may simply say that, the executive can declare a state of emergency and leave the rest of the details to legislation, to the parliament to decide, how to then regulate that power. But increasingly over the past few decades, newer constitutions take a different approach, and they often set out in much more detail and at greater length the power to declare a state of emergency, who can declare it, the process by which it's declared, and processes for renewal, as well as what impact, if any, it has on rights and what checks and balances are still in place during that time. So basically we have a shift from very little detail in constitutions around an emergency to much more specificity and detail. And in some sense that is in part a recognition of the potential ways in which emergency powers can be abused. So the idea that if you put more details into the Constitution, then perhaps you have a greater chance of being able to prevent the abuse of that power. Whereas if you leave it and delegate it as a power to the legislature, it's possible that emergency powers can perhaps be abused more easily. So what is a state of emergency then? Well, we know that it's something in a time of grave necessity or in exceptional circumstances. And so a declaration to declare an emergency is a decision made in response to certain exceptional circumstances and has particular impact on how the branches of government, the executive, the legislature and the judiciary function. So in normal times, they have a set of roles and responsibilities. They have limits on their authority. And yet in a time of emergency, this changes. And it can change in a number of ways. But in particular, it might allow the government to impose increasing restrictions on individual rights in ways that wouldn't be the case in normal times. So we talked last class about how many constitutions have bills of rights and they protect a range of things from civil and political rights to economic and social rights. In an emergency, this is where many of those rights may be restricted, although certainly there is recognition that some rights, very fundamental ones such as the right to life or to seek habeas corpus, should still apply in an emergency. So what counts then as an emergency? Well, sometimes constitutions do set this out in some detail, or perhaps in legislation. It might commonly be a war, although that is certainly less frequent in the recent decades, and it's more likely to be perhaps due to internal conflict within a state. We've also seen emergencies in times of financial crisis, and of course, the times in which we live now. The global pandemic is also a different kind of emergency. In some contexts, the term state of emergency is used, but there are also other terms. So martial law is used in some contexts, or states of siege, states of exception is another term. So different ways of referring to a similar type of situation, an exceptional situation, and one of a grave emergency. Okay, so let's look then at what some of the conditions constitute an emergency and who has the power to do that. So obviously the authority to declare a state of emergency is not a light one. It's one that comes with significant responsibilities. And so often a constitution will set out which branch of government or which political actor in particular has the power to declare an emergency. Sometimes this might be the head of state, such as a president, or the executive, more broadly, the cabinet. It might be the legislature, or it could be a combination of these. So it might be that the president can declare an emergency, but that declaration is subject to approval by the parliament of the day. So a number of different ways in which that authority is delegated. So the effect of a state of emergency, so what happens then? In many cases, this is fundamentally about enhancing and expanding the power of the executive. And this inevitably means a reduction in the limits, the ordinary limits on their power. As a result of that expansion of executive powers, that might lead to the shrinking of the role of the courts. Now, in some cases where martial law is declared, the courts and their role may in fact be replaced, perhaps in part for some particular offences, by military tribunals that have jurisdiction to hear civilians. In some cases, of course, the courts might not play a role at all, but we'll come to that a bit more in a moment. The legislature as well might have a reduced role, or in fact, it might no longer exist, so it may be disbanded. And in talking about the increase of executive power, of course, that may include armed forces. So whether that is the military, the police, or other law enforcement agencies. And of course, in more extreme cases, it may in fact be that a military leads that state of emergency. Now, of course, fundamentally, a state of emergency should be something that is temporary rather than permanent. It's a suspension of the ordinary ways of doing governance in the ordinary times. And so there is a sense in which at some point you transition back to the ordinary constitutional framework. So what then happens for human rights? In many newer constitutions, there is more detail around how, to what extent states of emergency affect individual rights and what protections still exist at this time. Now, of course, we are all now very familiar with some of the sort of practical ways in which rights might be affected. This includes things like freedom of movement. We could also include freedom of expression. There are a range of freedoms that we may have restricted during times of emergency. And this might occur practically through lockdowns, border restrictions, curfews, limitations on either public gatherings or private gatherings, as well as potentially restrictions on what remedies you might be able to claim in court, or to what extent you can enforce constitutional rights. Now, international law, it is recognised that fundamental rights, such as the right to life, are non-derogable. That is, that they cannot be compromised or cannot be taken away, even in a time of emergency, precisely because they are fundamental rights. And in addition, it's usually recognised that the particular remedy of habeas corpus, so if someone is suspected to have been arbitrarily arrested and an application is made to the court, asking the court to produce that person and to inquire into whether their arrest is lawful or not. So that remedy in particular, again, there's an emphasis on that, should still apply in an emergency. So turning now to time limits, and this is a really important part of an emergency, because as I mentioned, if an emergency is something that is supposed to be temporary, then a mechanism to ensure that that is the case is, of course, setting a time limit. And this allows, this ensures that the length of an emergency has an end date, that there's a definite time limit and a clear time period, either by which it is renewed or by which it ends. And so what a constitutional legislation will usually do is set up processes and procedures to extend the time limitation, as well as a legitimate basis for the extension of that emergency. So for example, it might be if the military is in charge, they may have to report on the current conditions and explain why there is a need to extend that emergency. Now, in this process of extension, it might involve different institutions and branches of government. So if the head of state or the president is the body that has the power to declare an emergency, it might be that the process of extension requires the involvement of Parliament and the approval of Parliament to vote on any extension. There are a range of possible time limitations that you see around the world. Some are very short, 7 days, 14 days, 21 days. Others are much longer, 60 days, 90 days, a year even. So there's a lot of variation in what constitutes a appropriate time limit. And obviously that often in part is relevant to the kind of emergency that is taking place. So during this emergency, this suspension of normal government, various roles and functions of the government, of course, may be suspended. And there are a couple of sort of key things or powers that are usually understood to be suspended during a time of emergency. So, for example, there's a question and debate about, well, can you amend a constitution during a state of emergency? But obviously, given that it is a time of crisis, given that amending a constitution is something that is done with a level of seriousness, with a sense of gravity, that many would say, well, no, you shouldn't amend a constitution during a state of emergency. Another might be elections. So it's common for elections to be postponed during a state of emergency until it comes to an end. And another, and we've seen this during the COVID-19 pandemic, is that in areas where there are conflicts, there might be a ceasefire. So towards the start of the COVID-19 pandemic last year, the UN Secretary General actually called for a global ceasefire. And that was in recognition of the fact that this global pandemic would require the attention and the resources and the time and energy of governments around the world. And, they placed emphasis on the fact that there shouldn't be conflict at this time. And if governments were continuing to engage in conflict with other armed groups, that would take attention away from the pressing need to stay focused on the global pandemic and respond primarily to that. I think, interestingly, across Southeast Asia, on that point of ceasefires, I think in Myanmar there was to some extent a ceasefire, although only partial. So what the military did is they declared a ceasefire, but added a caveat and an exception and said, well, but not in areas where there are terrorist organizations. And so at that time, it was referring in particular to groups in Rakhine State and Chin State that had been declared by the government as terrorist organizations. And so in that sense, the ceasefire certainly wasn't complete. So coming now to the role of courts. So I've talked a bit about the executive being the primary branch that often plays an oversized role in a time of emergency. We've talked a little bit about the legislature and the role that it might play in acting as a check and balance on executive power. And of course, the courts might play a role too. And there's a range of ways in which they might do this. One is around considering the sort of constitutionality or legality of the declaration of emergency itself. So there might be a question about either whether the process of declaring an emergency was followed, or whether there was a valid reason to declare an emergency in the first place. So a question of what constitutes an emergency and whether the parameters around what constitutes an emergency in the Constitution or in law was followed. As well as courts playing a role in reviewing any limitations, regulations or restrictions on rights that have been imposed during a time of emergency. So, questions around, are border restrictions appropriate, or do they infringe unnecessarily on the right to freedom of movement? Are curfews, are lockdowns, are they appropriate and necessary restrictions on rights in a time of emergency? And so in this sense, the courts are potentially have a role in overseeing the legality of executive action taken during this time. In addition, we might also see courts playing a role in infringements of emergency powers or of the regulations that are put in place during a time of emergency. So for example, even in Australia, we have seen people who are not wearing masks, being fined, or who have breached various border control or lockdowns, even being jailed. And so those are the ways in which courts might also play a role. Now, of course, in many contexts, the courts, though, may actually not play a role. Or if there are separate tribunals set up, such as military tribunals, they might have that function taken away from them. And I think when we look across Southeast Asia, it does seem to be the case that there is not a large role for the courts during a time of emergency, although with some exception, with some constitutional courts hearing cases. That is, that courts don't seem to play a large role in limiting executive power during a time of emergency across the region. So it does raise a question then of, well, what are there other substantive limits on executive power during these times? So let's come now to some of the debates on emergency powers. And in many ways, it fundamentally comes down to this question of, well, is a state of emergency still within constitutional and legal boundaries, or is it effectively facilitating the executive to act entirely outside of the legal system? Now, there are a range of different scholars that have weighed in on this. The political theorist and jurist Carl Schmitt was of the view that, well, it is precisely the sovereign who can decide on the state of exception. And so in that respect, viewed emergency powers as being outside of the constitutional system. There are other scholars who have argued that, well, we can actually think of emergency powers as something of a constitutional dictatorship. But unlike a normal dictatorship, a constitutional dictatorship is reinforced by the idea or the intention to restore constitutional democracy. So there is a clear sense in which it is not going to be prolonged, but that the state of emergency is for the purpose of restoring constitutional democracy. Now, there's also the concern that's often raised that the executive is not subject to any limits during this time. Some scholars have actually suggested that maybe that's not a bad thing. Maybe the executive is actually precisely the branch of government that has the information, it has the powers, it has the resources, and needs to act unbound in states of emergency, although that's one particular view. But I think broadly speaking, there is still a sense that there should be some limits during a time of emergency. So let's think about this idea of limits on government powers during a time of emergency. So some scholars have been talking about this idea of executive overreach or executive underreach. During a time of emergency, it's often the idea of executive overreach that is foremost in our mind. That is, we're concerned with preventing any abuses of executive power. We're concerned that a state of emergency will facilitate the executive taking unwarranted action. But some scholars more recently have been talking about the idea of executive underreach. And this comes from their observations during COVID-19, and particularly in contexts like the US or Bolsonaro in Brazil, as well as perhaps, we could probably name some countries in Southeast Asia, where leaders have effectively not taken action and in many ways have intentionally failed to act, despite the global pandemic. So, for example, there might be a reluctance to impose curfews. There might not be any public orders on wearing masks. There might not necessarily be border restrictions or other restrictions on movement. And so in that sense, the executive knows about the pandemic, they know about the risk, and they know what measures could be taken to prevent that risk, and yet they deliberately choose not to act. So this raises something of a challenge or of a puzzle because, on one hand, we presume that elected leaders or appointed leaders, whether it's a president or a prime minister, the head of state, that we when we observe them, we judge them based on their actions, their performance, and their achievements. So we expect them in their high office to act in a time of emergency. And so there is a question of, well, why would they not bother to use their powers? Why would they fail to address a major issue or emergency? So that is, why would they deliberately underreach in their powers? Now, there's a number of probably a wide range of reasons for that. It might in fact be that they have supporters who also support this underreach. And we see this in many countries where there is protest and support for not wearing masks, for ending lockdowns, for opening borders, all that sort of thing. And so there is a sense in which there are a number of reasons that executives might, in fact, decide to engage in underreach. I think this idea of executive overreach or underreach is an interesting one to think of in the context of Southeast Asia. And I hope in discussion time today, we can talk a bit more about what you've observed across the region in terms of how leaders and governments have responded, and which one of these, or combination perhaps, you've seen across the region. So Posen and Shepperley, who've been talking further about this idea, have suggested that actually executive overreach and executive underreach are not necessarily mutually exclusive. So you might have the two things going on at the same time. So there might be executive overreach of powers in one area, but then there is inaction or deliberate failure to act in other areas. Now, they do also say that, well, executive underreach doesn't include all failures to act. It obviously, a leader doesn't necessarily respond to every situation, or there may be good reasons why a head of state doesn't act. But in their concept, executive underreach is where there is an intentional failure, and where there is obvious evidence and information indicating possible actions that could be taken, and where this was not, where they didn't respond to that information or action. So they were deliberately underreaching. Now, so I might move on, but let's come back to that in the question time. Okay, so just to expand this idea further, I think we can also consider the idea of legislative or judicial overreach or underreach. So it's not necessarily a phenomenon confined to the executive, but if courts perhaps overstep their powers, or order the executive to do certain things, we often see that judicial activism as overreaching their powers in some contexts. And also perhaps even the legislature may go beyond their powers, or alternatively might fail to act in certain situations and leave things to the executive. So there's a number of challenges or problems then that arise with this idea of the overreach of executive power. And of course, this is the common problem that we're usually concerned with in a state of emergency. So one is that by overreaching effectively, what the executive is doing is overstating the risk or exaggerating the risk in ways that are sort of disproportionate. So the actions taken go further than what is really needed for the situation. And so in this sense, the executive uses the state of emergency perhaps to reinforce their powers, perhaps to enhance their popularity, or to increase their chances at the next election. And so in this way, the problem fundamentally with executive overreach is that it may potentially allow for more authoritarian governance measures to not only to creep in, but to become normalized and become part of normal governments rather than the exception. And of course, we have seen in many countries in the region at times where emergency powers have extended for many years or extended periods of time, rather than being on a temporary basis. Now, in contrast, this problem of executive underreach, or the problems that it raises, are slightly different and the obverse of that. So here you have the executive actually understating the risk, perhaps downplaying the risk, maybe even publicly, and deliberately failing to take action when certain action is needed. And as a result of this failure to act and this understatement of the risk, it might directly put the public's rights and interests at risk because of that inaction. And so we can think about the fact that in COVID-19, if you're not wearing a mask, that could then affect others. And so the failure of the executive to regulate the use of masks could potentially contribute to that problem. In the same way, if the executive doesn't use other powers such as lockdowns or curfews, that again might have an impact on individual rights and their safety. So I think there's challenges and problems with both executive overreach and executive underreach. Maybe they have their own concerns, and that we need to be aware of both and not simply this idea of executive abuse of emergency powers. So coming now to the legal responses to the pandemic in particular, which we've kind of begun to hint at. And I think, first of all, there's a fundamental question, particularly in the region of, well, has law been used to respond to the pandemic? Is there actually a legal basis for the government's response? And in some cases, there might not necessarily be. But in many cases, either there is a constitutional basis for the government's response, there may be a legislative basis, as well as executive basis for the powers and authority they exercised. Now, in some cases, this might actually have predated COVID. So we know that in many jurisdictions, there might have been pre-existing health laws, there might have been pre-existing disaster management laws, or pre-existing emergency laws of some kind. And so those pre-existing laws in many countries have been used to respond to the pandemic. And often they've had to be adapted somewhat. And in some cases, new legislation has instead been issued more specific to the COVID-19 crisis, and that's allowed for the tailoring of the emergency response to this particular kind of unusual emergency. Now, aside from the three branches of government, and in some sense we've been talking at the national level, of course, in many countries, whether they are federal systems or whether they're more decentralized systems, there has also been a role for subnational governments. And this has raised certain legal and political questions around the relationship between central governments and subnational governments, the relative sharing of power or limits on their power, and which of these authorities and when is responsible during particular times of emergency, and what for what kinds of matters. And certainly we've seen that in Australia and in our federal system, and the way that different state governments have responded with different kinds of lockdown measures, different kinds of economic stimulus packages, different kinds of public regulations. Now, another question that has been of concern to scholars and of great interest during this time is, well, what impact is COVID-19 having either on the state of democracy globally or authoritarian rule? So that is, do we see any difference between governments that were democratic prior to COVID? Has it either enhanced the nature of democracy, leading to robust discussion and debate and democratic decision making, or has it actually led to democratic erosion and decline? And likewise, in governments that are more illiberal or authoritarian pre-COVID, has that exacerbated that situation? Has it continued to facilitate authoritarian rule? Or again, has it led to some sort of decline? And I guess the decline I'm thinking of here is that when, particularly if there is a case of executive underreach, where the executive fails to act and where the public is dissatisfied with that response, that perhaps that might in fact prompt a turn to demands for a new government or for greater democracy. So what do we see then across Southeast Asia, very broadly speaking? Well, one, I think, is that in most contexts, it has either been the use of existing legislation and or of new specialised legislation, as well as executive power. So I think there's only a handful of contexts where constitutional powers have been used, but in most it has been the use of legislative powers. As I mentioned earlier, there hasn't been a large role for the courts as a check on power, although there has been some role for the courts in relation to the enforcement of certain public regulations. I think we can think about both examples of the abuse of executive power and overreach, or as well examples of executive underreach across Southeast Asia and often within the same country. We've also seen elections postponed or delayed in some countries, although not all. So obviously Indonesia is an example of one that postponed its regional elections last year and held them at a later date, whereas countries like Myanmar went ahead with their elections without delay. Okay, so I thought just in the remaining time that I have, and I'll finish up in about 5 or 10 minutes, is just to talk very briefly about the case of Myanmar in relation to emergency powers, because often in many countries there is quite a long use of emergency powers, and in many respects COVID-19 is only the most recent use and builds on much of that past practice. So the first is to note that in many countries, post-colonial contexts, emergency powers have origins in colonial rule. And this is certainly the case in Myanmar, as it is similarly in India, given they were both part of British India and colonized by the British. And there's reference to what's often known as Section 144 orders or Section 144 powers. This is a provision in the Criminal Procedure Code that enables administrators to go to a judge to seek an order in cases of public nuisance or disorder, and to seek an order so that the court will perhaps impose a curfew and restrict movement and limit freedom, and in that way allow the executive to take over control. That Section 144 power is fairly broadly defined, and in more recent decades has been used by the executive and actually by the military in Myanmar to maintain control. And nowadays the courts are not involved at all in that legal decision-making process. So we've seen the use of Section 144 powers at many important points in Myanmar's history. In 1974, in 1988, in 2007, and certainly even after the reform process of 2011. So we've seen it in the use of Section 144 in Rakhine State in relation to the Rohingya, as well as in response to many other types of conflict and crisis. But what has become apparent is that most of the time Section 144 is kind of the precursor to the constitutional emergency powers declaration. So in some sense it's a stepping stone, it's the prior step before at a national level, a constitutional emergency is declared. Now, of course, the period from 2011 to 2021 has had a range of conflicts, and among those, the Rohingya crisis stands out as one that was particularly acute, and that did lead to the declaration of constitutional emergency. There were two other situations that you can see there on the screen. One which was in relation to anti-Muslim violence, and the other Kokang state, which is in a part, or I should say Kokang region, which is close to the border of China, where there was fighting, and so a constitutional emergency was also declared there. But interestingly, there were also many situations where authorities, but that is the National League for Democracy at the time, decided not to declare an emergency. So from 2016 to 2021, the National League for Democracy was in something of a bind because they didn't want to approve a constitutional emergency. And the reason that they didn't want to do so is because they were concerned that the military would use a constitutional emergency as an excuse to take over permanently. So they were precisely concerned with this question of executive overreach, or in this case, military overreach. This occurred in 2016, 2017, so there was actually explicit calls by the military, who also sit in Parliament, for a constitutional emergency, and again in 2020 during the the COVID-19 pandemic, while the NLD was still in government. And so that didn't happen, and the National League for Democracy instead used existing law and executive power to respond in those situations. But of course, then we see a kind of classic example of the overt abuse of emergency powers. On the 1st of February this year, the military staged a coup, although it cloaked this action in the legitimation of an alleged constitutional emergency. So that is, the military referred to the provisions in the Constitution on a state of emergency in an attempt to claim that the actions were legal, but of course there were many issues along the way, and it is fairly evident that that declaration of emergency wasn't constitutional, in that there wasn't a legitimate basis for that emergency, but also that the process for declaring that emergency wasn't actually followed. So I use that just as an example and a brief overview of how the use of emergency powers has changed over time in the region, their origin in the colonial era, but then their continuing use today, and those very real risks in many countries of executive abuse of power. Okay, so I think we'll finish up there, because I've probably gone for about 60 minutes, I think, or thereabouts. So just to note that for the seminar we have next week, we'll focus on the human rights situation of the Rohingya in particular, and how that situation helps us to think about the nature and state of human rights in the region and the very real risks to them. So thank you, and I think I'll hand it back to, is it Milda or Nanda now?
Yes, it's me. Thank you, Professor Melissa, for the delightful presentation. We have learned so much, although in such a limited time. I think we'll go ahead to the chat column. There is one question and also two questions directly to me. Probably the students don't want to make it public, but that's okay. And before I read that, I would also like to ask students who might want to participate or interact with Professor Melissa lively. If you have any questions, please do so. Just raise your hands, use the reactions buttons. Okay, I will read the first question in the chat box, Professor Melissa. This is Amar, and he is asking about, in Indonesia, our government is making new regulation about quarantine, but there are also older quarantine regulations, but they just have changed the name. And at some point, the reason they're using the new regulation because they don't want to be responsible for giving the people of what they need, especially the essential need like food and etc. So his question is it allowed to do so, or is the government doing it illegally? Probably this is related to the explanation about that such emergency powers should be temporary and not doing it fulfilled and so on. So that is the first question. I might read the second question if it's okay with you. And so the second question is from Rizky. Hello, Miss Melissa. May God bless you. I want to ask a question. In times of pandemic, many people are suffering and dying, trying to save their lives because government regulations make it difficult for them to earn an income. And then the government tried to provide assistance through the minister, but it turned out that the minister was corrupting AIDS funds for the community. Then, in consideration of the many people who were dying during the pandemic, many people demanded that the minister shall be sentenced to death. And I think it's worth it. Even Indonesian law provides room for that, in her opinion. And as I know, the judge's decision is very light for the minister's sentences. I just want to know your opinion in view on the pandemic situation. Thank you. So that's two questions from the students.
Thank
Melissa,
you.
I will give you time to respond.
And thank you to those students for starting off the questions for this evening. So on the situation of Indonesia, or perhaps let me answer it at a more general level to begin with, and perhaps caveat my earlier discussion on time limits, because I think you raise a really interesting point, which is that obviously during this global pandemic, we're more than a year and a half in. And so, in fact, it is a prolonged crisis. So I think that obviously the idea of a time limit on an emergency inevitably depends on the type of emergency. And in some sense, that's why it's important to have review processes built into a emergency time limit and a process of review. And so I think what we have seen across the region is that obviously governments have changed and shifted their strategies over time. As COVID numbers have gone down, some countries have opened up, and then as cases have gone higher again, they've changed and introduced different legislation. And some governments have of course been more consistent than others in the way they have set that up and in the way they have communicated that to the public. So on the specifics, I'd need to know a little bit more of the specifics of that regulation, but I think you're right that obviously to issue that new regulation would need to have a legal basis for it. I think that the concern that you seem to raise there is that this time around, some of the provision of goods and food has perhaps been omitted. And I think this has been a challenge for governments in terms of, when and how to, whether it's economic stimuluses or more practical provision of goods, when and how they do that. So certainly in a case where there is significant need, I think you're right to raise that question about, well, why isn't the government continuing to provide that? The second question, as I understand it, was perhaps particularly concerned with the issue of corruption, I think. And obviously that is one that is shared by many countries in the region. And as you point out, in Indonesia, there has been particular concerns about how government officials have administered funds that have been related to the COVID crisis and aid, aid funds that have been distributed in particular. And I think people have right to be very concerned. And obviously this comes on the back of 2019 and the changes to the KPK and the real concerns about the attacks on that institution and on the way in which that institution has become closer to government and less independent. And of course, we all know that the KPK has been really at the forefront, at least in the past, of efforts to promote anti-corruption efforts. And so in the sort of absence of that institution or the decline of that institution and its impact in this area, I think you're right that it is particularly concerning. I am not aware that it could go as far as the death penalty, and obviously that's a whole nother debate that perhaps we won't get into. But I think many people would say that perhaps maybe there are other options, such as a life sentence rather than the death penalty, even though I appreciate the serious nature of the crime and people's concern about corruption over what were supposed to be aid funds at a time when people were in particular need. So thank you.
Thank you for the answer, Professor Melissa. I have two other questions that are directly chatted to me, but I would allow for any participants, particularly students who wish to ask directly to Professor Melissa, please do so today. Does anybody have or want to raise a question directly? I will give some time. If not yet, then I would go to the chat column directly to me. Probably the students don't want to make it public, and that's okay. So there's two questions, Professor Melissa. The first one's that, are there any best practices of states that have used their emergency powers legitimately and not disproportionality? So about the best practices, I'm not sure if this is particularly in ASEAN or general global. And the second question is, the United Nations human rights experts have warned states to avoid overreaching security measures in their response and reminded states that emergency powers being used to combat the spread should not be used to squash dissent. However, we have seen that many minorities have been affected by these security measures. What is your opinion on this? So first is about the best practice of states, and second is about the affected measures by or towards the squash of dissents or minorities.
Okay, thank you. Both of these are quite big questions, and I guess it depends on what you are asking in particular. Maybe let me take the second question first. So you're right, and that statement from the UN is obviously an important one and something that I didn't really mention during this seminar yet is, as you said, first of all, the impact on freedom of expression, and that some governments have used the COVID crisis to further reduce dissent and opposition to their rule, to limit freedom of expression, whether that's particularly online, and that is really concerning, as well as, of course, possible limits on the media and media freedom, the safety of journalists and that sort of thing. So I agree with you that that is very real, and that that's a real challenge, particularly because this type of crisis, a global health pandemic, to some extent requires valid information to be clearly communicated to the public in an ongoing fashion, so that the public has easy access to the facts and to information, and then it's not misled in any way, given the nature of the crisis and the way in which people need to be able to respond and adapt their behaviour based on that information. You're right that there has also been a concern that minorities have been targeted during the pandemic. And I'm reminded of, I think even very early on in that first month or two, we saw across the region different kinds of minorities being blamed for the initial spread of COVID. Of course, in many countries, that blame has been directed at the Chinese, even though obviously this is a virus that knows no boundaries and is not caused by any one group as such, or can be spread by anyone. In places like Myanmar, we saw the Rohingya being blamed, so the minority Muslim group, and that was in part because I think one of the first cases at the time was a Rohingya person who had travelled back to Myanmar. But of course, that targeting is, unnecessary and discriminatory. And in other contexts, it was different kinds of minorities that were targeted. Sometimes, again, an example from Myanmar is of how COVID regulations were policed, and who got caught with alleged breaches of the regulations and what kind of penalty they were given. So, for example, there was a situation where a Christian pastor from a minority group was jailed, I think, for holding a public gathering during COVID-19, which clearly was in breach of COVID regulations. But then this created some outcry because there were Buddhist groups also holding public gatherings, and yet they hadn't received the same kind of sentence or punishment. And so there was a sense that the policing of COVID-19 regulations had been unfairly discriminatory towards certain minority groups. So I agree with you on that case. On the first question, in terms of best practice in emergency powers, I guess to some extent my presentation today has hinted at that in different ways. So one, the idea that an emergency is defined in a limited way. It obviously can't include all situations, that is limited to particular kinds of necessity and exceptional situations. A best practice in terms of having potentially multiple institutions or branches of government involved in the decision to declare an emergency, as well as involved in decisions around whether to renew a state of emergency. And then best practices around things like short time limits, reviews on time limits, as well as still recognising fundamental rights, even if there may be a need for restrictions on other kinds of rights. So I'll leave it there. I think we might have another question in the chat.
Yes, thank you, Professor. So the next question is from Fadila. Dear Ms. Melissa, nice to see you here. I'm Fadila. I want to ask you, a few moments ago, Indonesia was found a case manipulating PCR tests. And so if this happened in your country, how will the punishment be? So it's typically raising a question about the manipulating the PCR tests that we have done witness, unfortunately.
Look, I don't think I'm the best person to answer that question. I think it would depend, and I'm not familiar with a particular case in Indonesia, as you say, given that it's just happened. So we might have to leave that question to another time.
Yes. Does anybody have any other questions? I will give the time if you want to directly. And please, if you should raise a question in Bahasa, it's perfectly fine. And just for information that Professor Millie Crouch can understand well of Indonesian language, so that not be a boundary. Does anybody have any comments or questions for today? I'll give the time. Yes, so feel free to use the chat box, or also automatically using the reaction, you can state your questions personally to her. Does anybody have any more comments or questions? Okay, Professor, I wanted to ask you something about the necessary part of the emergency powers. So I think some of the students in class, not in this 3-in-1 program, have raised a question about how to assess whether this type of situation or condition could be stated as a necessity. So are there any thresholds that we could use to assess these kinds of situations, Professor?
So as I understand your question, I mean, first of all, there's the concern about what impact this has on democracy, and how do we tell whether certain measures are necessary. I mean, if we're talking about courts, you know, at a basic level, when we're thinking about different rights and whether limits on some rights might affect others, or courts often engage in what we refer to as a proportionality analysis. So this kind of balancing and weighing of competing interests. But at a broader level, so beyond courts, you know, I think for this COVID-19 crisis, it is in many senses a test of democracy and the kinds of just public deliberation and debate that we have about, what is necessary in a certain situation, and, you know, when conditions change, how governments adapt to that. So I think more broadly, you know, what we see is different ways in which governments either facilitating and allowing this public discussion debate to play out, or in some cases, you know, limiting it and confining the terms of the debate. So I don't think there's any sort of easy answer or test at a sort of broader public level, but I do think it is an opportunity to engage in discussion and debate on what limits are necessary in particular contexts. And as I think I mentioned in the first class, you know, it is quite contextual, you know, what might be necessary or appropriate or proportionate in Indonesia is going to be different to Australia, and what might be proportionate and necessary in West Java might be different to East Java. So, you know, I think in that sense, that's where democracy needs to be more localized and more contextualized.
Thank you for the answer, Professor. And so before I end this lecture, I would give one more chance to students who might have final questions or comments. But if not, I believe that Professor Melissa can, if you may, you can write your email in the chat box, and approximately some students could ask you through email any questions provided to you. But I do want to inform to all the participants that we still have one more session with Professor Melissa, and this will be held on Tuesday next week on September 28th, 2021. And there she will specifically raise the case study of Myanmar, emergency powers, human rights, and the military coup. So that might be very interesting for some students, typically or specifically to those who are actually now in the final year, who are examining or making this case study in Myanmar as a thesis. So please join her last session of 3-in-1 program today. And therefore, if there are no other questions, I want to thank Professor Melissa for this lectures today. We have learned so much in terms of, you know, the definition of emergency powers, how the increasing restrictions are posed in several countries, typically in the ASEAN region, how the role of executive, the role of courts, and etc. And thank you. She has stated her email on the chat box for students who might want to ask her further questions privately. Please do so. And once again, I thank to all of the students and participants held today. And thank you again, Professor Melissa. We'll see you next week on Tuesday. Thank